The Valley Current.
Imagine a government, right, paying a family a literal $1,000 federal cash bonus just to celebrate their newborn baby becoming a U.S. citizen.
Right, which sounds like a great deal for the family.
Yeah, exactly. But then, and here is the crazy part. At the exact same time, that same government is suing in federal court to strip that exact same baby of their citizenship.
It sounds completely made up, honestly, like a glitch in the Matrix.
It really does. But that is not a hypothetical thought experiment. I mean, that is the literal operational reality of the United States government as of August 6, 2026. You are looking at an administration that is, subsidizing birthright citizenship with one hand and then trying to dismantle it with the other. So welcome to a brand new deep dive.
Yeah, thanks for having me. The paradox here is, well, it's built right into the policy. I mean, we're basically witnessing this unprecedented collision of executive power, constitutional theory, and, the modern political machine.
Totally. So I spent the entire morning going through this massive, incredibly highly detailed briefing and newsletter from Entrepreneur Law Group, PLLC, or ELG for short. And they laid out the whole anatomy of what just happened.
It's a dense read, for sure.
Very dense. But to set the baseline for you listening, President Trump just signed 2 new executive orders targeting birthright citizenship. And he did this merely 6 weeks after the Supreme Court definitively struck down his first attempt to do the exact same thing.
Right. I mean, 6 weeks is barely enough time for the ink to dry on the Supreme Court's ruling. It's incredibly fast.
It really is. So our mission for this deep dive today is to unpack the strategy behind these headlines. We're looking at the legal maneuvers, the empirical data, the public reaction, and even how financial prediction markets are trying to price the outcome of these lawsuits.
Yeah, which is a whole fascinating angle on its own.
Right. The goal here isn't just to, get bogged down in legal jargon or review the law. It's to understand the game theory of the courts, like why reissue a policy that just got struck down? How does that actually work in practice? But before we start tearing into the mechanics of these executive orders, we really need to establish some ground rules for this discussion.
Yeah, that is a crucial step because, this deep dive covers some incredibly highly charged political and legal topics. We are dealing with deeply debated immigration policies, constitutional boundaries, and, actions by the current president. So we must make our position explicitly clear to you, the listener.
Exactly. Total neutrality.
Right. Neither of us is taking a political side here. We are not endorsing any of the viewpoints presented in the ELG briefing, nor are we condemning them. Our only job today is to impartially report, analyze, and, synthesize the factual content, the arguments, and the legal theories that were provided in our source material.
We're just the messengers.
We are here to map out the landscape so you can understand the architecture of what is happening. We are absolutely not here to tell you what to think about it.
Right. We are just the guides walking you through the terrain.
Yeah.
So let's look at the bedrock this whole situation is built on. We have to go back to the Supreme Court case known as Trump v. Barbara.
Right, which was a huge deal.
Yeah, massive. So on Inauguration Day in 2025, the president issued a sweeping executive order. The premise was pretty straightforward. Deny citizenship to the children of undocumented parents and temporary visa holders.
And that went straight to the courts.
It did. The Supreme Court took up the case, and on June 30, 2026, they struck it down. Chief Justice Roberts wrote for a 5-justice majority, and he stated that the 14th Amendment guarantees citizenship to, quote, virtually everyone born on American soil. I mean, it felt like a massive, definitive constitutional door just slamming shut.
It really did. I mean, that original January 2025 order was this frontal assault on the concept of just unconditional birthright citizenship. It attempted to resolve a massive constitutional question in just a single broad stroke.
Like a sledgehammer approach.
Exactly. The administration's equation was super simple. Temporary or unlawful presence of the parent automatically equals no citizenship for the child. But the Barbara ruling foreclosed that specific sweeping application. But, a constitutional door slamming shut in one area often prompts an administration to just start checking all the windows.
Right, which brings us directly to these new August 6th orders. The ELG briefing uses this great framework, kind of like an ELI 5 explained like a 5 sports analogy.
Yeah, hacker analogy is good too.
Right. Well, the sports one is like the Supreme Court tells the player that a play is against the rules. So the player comes back a month later with 2 slightly different plays. But you mentioned the hacker one, which is even better. Instead of treating the Supreme Court like a referee whose whistle ends the game, the executive branch approaches this more like a hacker probing a firewall for an open port.
Yeah, I love that comparison because if you throw a massive brute force attack at the system, the firewall, the Supreme Court, it just blocks it completely.
Right.
But the hacker doesn't just give up. They come back and they start testing tiny, specific vulnerabilities, looking for just one port that might let them slip through.
So my question is this just flat out defying the Supreme Court, or is this like a known legal strategy?
Oh, it is a highly calculated known legal strategy. It's called iterative narrowing. It is a proven method in constitutional litigation. When an executive policy gets invalidated at its absolute maximum breadth, the executive branch basically reissues successively narrower versions of that policy to probe exactly where the judicial line actually sits.
Like trying to find the electric fence in the dark.
Right, exactly. And the ELG briefing compares this directly to the travel ban progression back from 2017.
Oh, right. Version 1.0, 2.0.
Exactly. We saw version 1.0, then 2.0, and finally 3.0, which eventually culminated in a government win at the Supreme Court in Trump v. Hawaii.
So you are basically decomposing a massive unconstitutional rule into these smaller, bite-sized fragments.
Precisely. You create what the briefing calls exception-shaped fragments. And by doing that, you force the courts to define the exact outer boundaries of the law on an excruciatingly granular level. And, this behavior is anchored in a much deeper constitutional theory called departmentalism.
Okay, departmentalism. I saw that in the notes. Break down how that theory actually functions when an administration applies it in real life.
So departmentalism is basically the view that the executive branch has the inherent authority to act on its own independent interpretation of the Constitution.
Regardless of what the courts say.
Right, regardless of what the courts say. Up until each specific application of their policy is individually enjoined by a judge. The briefing points out that this is applied departmentalism in action.
So they aren't just ignoring the court entirely.
No. The executive branch formally acknowledges the Supreme Court's authority to decide cases like they aren't defying the core holding of that famous case, Cooper v. Aaron, which established judicial supremacy. But what they are doing is hollowing out that supremacy operationally.
They hollow it out by treating the Supreme Court's ruling as incredibly narrow. Like, if the court strikes down a rule that applies to Group A, the administration comes back and says, okay, sure, we acknowledge Group A is protected, but what about Group B? What about Group C?
You've isolated the exact mechanism there. They are exploiting the distinction between a judgment and a precedent. A court's injunction only legally binds the specific parties and the specific provisions challenged in that exact lawsuit.
Everything else is just precedent.
Exactly. Everything else in the broader legal world is only bound by precedent. And a departmentalist executive treats precedent as, well, somewhat advisory. They view a Supreme Court ruling not as this blanket prohibition, but honestly as an invitation to find the loopholes.
Wow. And the cost-benefit analysis of this game is completely skewed in favor of the president. The briefing points out that the costs in this repeated game of litigation are totally asymmetric.
Oh, incredibly asymmetric.
Because for the executive branch, iterating a new policy costs almost nothing. It is literally just the stroke of a pen on a new executive order. But for the judicial branch and the challengers defending the precedent costs a full, multi-year litigation cycle and just immense institutional capital.
Right. The administration's dominant strategy is just to keep fragmenting the rule. Even if they have an incredibly low statistical probability of winning any single case, the expected value is still positive.
Because if they get even one tiny carve-out sustained by the courts, it compounds, right?
Yes. It creates a new restrictive precedent. And if they lose, they just monetize those losses politically by claiming the courts are obstructing their agenda.
It is a literal war of attrition waged through administrative law. But, the source material highlights a highly specific variable in the Trump v. Barber ruling that made this iterative strategy seem rational to the administration rather than just, tilting at windmills. We have to look really closely at Justice Kavanaugh's role in that June 30th decision.
Yes. The Kavanaugh variable, this is where the legal nuance is everything. Because while it was a 5-4 decision striking down the original order, the coalition of those 5 justices wasn't uniform.
Right, it wasn't a clean block of 5.
No, it wasn't. 4 justices struck down the order on constitutional grounds, stating it flatly violated the 14th Amendment. But Justice Kavanaugh concurred with the majority's end result. He voted to strike down the order, but he did it based entirely on a statute.
He didn't touch the Constitution.
Exactly. He relied on 8 U.S.C. Section 1401, which is the federal law codifying birthright citizenship. He completely avoided the constitutional question.
So by avoiding the constitutional question, he essentially flashed a giant green light to the administration's lawyers. He signaled that there isn't an ironclad majority of 5 justices willing to say the Constitution forbids any tampering with birthright citizenship.
That is absolutely the administration's interpretation. Because Kavanaugh didn't lock himself into the constitutional block, they view his statutory concurrence as a roadmap.
A roadmap to try again.
Yeah. It tells them that if they can find statutory workarounds, or just operate in the ambiguous spaces of existing immigration law, they might have a viable path forward. Commentators aligned with the administration immediately framed his opinion as an open invitation for follow-on measures.
Which is exactly what happened on August 6th. So let's transition from the theory to the actual execution, because to truly grasp this fragmentation strategy, we have to dissect the 2 completely different plays the president just called.
Right, these aren't just minor tweaks.
No, these aren't just minor adjustments to the old order. They are fundamentally distinct legal weapons. So let's start with Order 1, which the ELG briefing categorizes as the historical exceptions expansion.
Okay, so Order 1 is where the administration attempts to stretch the boundaries of the 14th Amendment directly. It targets the children of alien enemies, members of foreign terrorist organizations or FTOs, and individuals who, quote, lobby and act on behalf of foreign governments.
And the administration's public posture here is that this is entirely consistent with historical exceptions to birthright citizenship that the Supreme Court has already acknowledged.
Yeah, that's their claim.
And look, I understand the historical precedent for certain narrow exclusions. Like, the courts have long recognized that the children of foreign sovereigns or accredited diplomats or hostile occupying armies, they aren't granted automatic citizenship.
Right, the classic examples.
Like, if a foreign army invades and a child is born in their military camp on U.S. soil, obviously that child isn't an American. Same goes for an ambassador living in Washington, D.C.
The logic there is deeply rooted in international law and sovereignty. Historically, children of tribal members were also excluded before subsequent legislation changed their status.
But let me push back on how Order 1 attempts to apply those historical carve-outs today, because the briefing points out massive vulnerabilities here, especially regarding vagueness. Like, I can see the logic for an invading army or an accredited ambassador, but Order 1 applies to people who lobby and act on behalf of foreign governments.
It's incredibly broad.
Right. We are taking an exception meant for a uniformed invading force or a high-level diplomat and applying it to a public relations consultant working for a foreign oil company in Texas, or like a low-level clerk at the United Nations living in New Jersey. The breadth of that language is just staggering. How does that work?
Well, your skepticism is entirely validated by the ELG analysis. The briefing explicitly describes Order 1 as legally radioactive.
Radioactive. That's a strong word for a law firm briefing.
But it's accurate. The administration's legal hook relies on taking the hostile occupation category and stretching it to cover modern terrorist organizations, while simultaneously stretching the diplomatic exception to cover incredibly vague categories of foreign agents and lobbyists. And the reason this is so legally provocative is that it directly attacks the jurisdiction clause of the 14th Amendment.
Right. The phrase granting citizenship to those born in the U.S. and, quote, subject to the jurisdiction thereof.
Yes. So historically, an accredited diplomat has diplomatic immunity. They are not subject to our jurisdiction in the ordinary sense.
If they commit a crime, they can't be prosecuted.
Exactly. If a diplomat speeds down the highway, they cannot be pulled over and prosecuted by local police. Therefore, their children are not subject to the jurisdiction of the United States at birth, but consider the FTO member or the foreign lobbyist living in New Jersey.
They don't have immunity.
Not at all. They are absolutely, unequivocally amenable to U.S. law. If they commit a crime, they go to a U.S. prison, they pay U.S. taxes, they can be sued in U.S. courts.
So they're fully enveloped by our jurisdiction.
Completely. The briefing explains that this specific tension exposes 2 fundamentally competing legal theories about what the word jurisdiction actually means in the Constitution. The first is the territorial amenability theory.
Okay, what is that one?
This is the mainstream view. If U.S. courts and laws can reach you while you are on our soil, you are subject to the jurisdiction. That was the core logic in a landmark 1898 Supreme Court case called Wam Kim Ark. And it was heavily reaffirmed just 6 weeks ago in Barbara.
Okay, so that's the prevailing law. And Order 1 is trying to revive the alternative theory.
Yes, the alternative is the allegiance consent theory. This one descends from an 1884 case, Elk v. Wilkins, which dealt with Native American citizenship. This theory argues that jurisdiction isn't just about whether you can be arrested on U.S. soil. It requires a mutual political consent, a formal allegiance between the sovereign nation and the parent.
Oh, I see.
Order 1 is deliberately engineered to force the current Supreme Court to choose between these two historical theories.
It's a calculated constitutional provocation. By picking categories like active members of foreign terrorist organizations and agents of foreign governments, the executive branch is selecting groups where the American public's intuition about allegiance is absolutely at its weakest.
Yes, they're trying to find the one scenario that might crack the territorial logic of the Supreme Court majority.
They're basically daring the court to issue a ruling that says, yes, the child of an active designated foreign terrorist born in a hospital in New Jersey is automatically an American citizen.
They are selecting the hardest possible factual matrix for the court to defend. It is constitutional bait, plain and simple.
Wow. Okay, but to understand the full scope of the August 6th maneuver, we have to look at Order 2, because it utilizes a completely different type of legal authority. It doesn't target the 14th Amendment directly.
Right. Order 2 focuses on the concept of birth tourism and frames the entire issue as a matter of immigration fraud.
So it's not about citizenship directly, it's about entry.
Exactly. It relies on immigration entry control authorities, specifically a statute known as INA Section 215. This order directs the State Department and the Department of Homeland Security to aggressively deny visas to foreign nationals who are traveling to the U.S. with the primary intent of giving birth on American soil to secure citizenship for the child.
Okay, so this is the heavily armored, legally defensible half of the package.
Yes. If Order 1 is a radical attempt to rewrite constitutional history, Order 2 rests on much firmer, established statutory ground.
Because it shifts the battlefield entirely. It fights the battle before birthright citizenship can even attach to a child.
Right. The executive branch possesses what is known as near plenary power, which translates to almost absolute, unquestioned authority over the admission of foreign nationals at the border.
Plenary power.
Yes. And furthermore, the act of denying a visa at an embassy abroad is protected by a doctrine called consular non-reviewability.
Okay, let's break down the mechanics of consular non-reviewability. It basically means the courts can't second-guess the embassy, right? Like, a judge in New York can't overrule a consular officer in London.
That is the practical effect, yes. If a U.S. consular officer in another country denies a tourist visa application, that decision is generally final.
You can't appeal it.
Not really. The foreign national usually cannot hire a lawyer and sue in a U.S. federal court to overturn the denial. The courts simply do not have jurisdiction to review the discretionary decisions of consular officers abroad. So by moving the policy mechanism to the visa application stage, Order 2 avoids the 14th Amendment trap entirely.
The briefing also points out that Order 2 isn't entirely novel. It essentially takes a State Department regulation that was implemented back in January 2020 and just codifies it, militarizing the enforcement.
Right. That 2020 rule already gave consular officers the authority to deny B visas, standard tourist visas, if they determined the primary purpose of the travel was to obtain citizenship for a child.
So by elevating that existing regulation to the level of a presidential executive order, they are prioritizing its enforcement across all agencies.
Exactly. And when you analyze Order 1 and Order 2 together, you really see the true architecture of the administration's strategy. It is a textbook example of asymmetric political warfare, basically borrowing a technique from legislative log rolling.
Explain that. Log rolling.
Yeah.
They are bundling a highly vulnerable, radical concept with a deeply pragmatic, defensible one.
Yes. You blend a measure that fights organized visa fraud and birth tourism, syndicates a policy that very few politicians will publicly oppose, with a measure that acts as a battering ram against the Supreme Court's constitutional precedent.
And you package them together on the exact same day.
In the same news cycle, exactly. And you dare your opponents to attack the entire package. It provides the administration with a highly defensible public relations position.
Because if you attack it, they say, oh, you support birth tourism fraud.
Right. They can expect to win at least a partial victory in the courts regarding Order 2, even while Order 1 absorbs all the constitutional attacks.
It's a fascinating structural play. Really clever. But, now that we've mapped out the legal strategy, we need to inject the empirical data into this conversation, because when the administration targets birth tourism, we need to understand the actual scale of the battlefield, like how large of an issue is this statistically.
The empirical data provides essential context that, honestly, often gets lost in the political rhetoric. The briefing cites data from the Migration Policy Institute, or MPI.
Right, the MPI data.
Yeah.
So according to them, in 2024, there were roughly 9,600 recorded births to mothers who explicitly listed foreign addresses on hospital records.
Which is a very specific metric.
Yeah. But when they adjust their models to account for underreporting, MPI estimates the true annual volume of birth tourism is likely between 22,000 and 26,000 births. Now, you have to contextualize that against the roughly 3.6 million total births in the United States every year.
Right, it's a very small slice of the pie.
Exactly. Even using the absolute highest estimate, birth tourism accounts for a maximum of 0.7% of all U.S. births. The ELG briefing frames it perfectly. It is a genuine problem of system integrity, but it is not a massive demographic transformation.
It is a fraction of a single %. But the briefing takes this data a step further by introducing a really critical counterfactual analysis.
I found this part so interesting.
It asks a vital question. What are the empirical consequences if you apply the logic of the original 2025 executive order to solve this more 0.7% problem? Like, if you broadly repeal birthright citizenship for the children of all unauthorized immigrants and temporary visa holders, what actually happens to the population?
The compounding effects are staggering. MPI estimates that if you strip birthright citizenship in that broad manner, the unauthorized population in the United States would grow by roughly 255,000 people every single year.
250,000 people compounding annually.
You would be systematically creating a multi-generational hereditary class of non-citizens who are born, raised, and educated on American soil, but who literally have no legal status.
Right, a permanent underclass.
And the source points out the historical irony here. Creating a permanent underclass based on circumstances of birth is the exact outcome the 14th Amendment was drafted and ratified to prevent in the aftermath of the Civil War.
It's true. If the administration's ultimate policy goal is to reduce the size of the undocumented population, broadly repealing just so lampily mathematically achieves the exact opposite result.
It is a striking contradiction between the stated policy goals and the mathematical reality. However, as we committed to at the beginning of this deep dive, we must present the full landscape neutrally. We need to examine the strongest legal and policy arguments for the administration's position, as detailed in the ELG briefing.
Yes, and those pro-administration arguments are structurally robust. They really shouldn't be dismissed. First, there is the undeniable fact that the Citizenship Clause does contain historical exceptions, and no Supreme Court has ever definitively mapped every single boundary of those exceptions.
Right. They've always left a little wiggle room.
The administration argues that they aren't violating the Constitution, they are merely modernizing it. They argue that defining alien enemies to include designated terrorist organizations is simply adapting the 19th century hostile forces exception to the realities of 21st century asymmetric warfare.
It is an argument for doctrinal evolution. Okay, I follow that. Second, the administration leans heavily on the concept of fraud.
Yes, the fraud argument is very potent. Organized birth tourism, facilitated by international syndicates, involves foreign nationals actively misrepresenting their travel intentions to consular officers to acquire a permanent sovereign benefit.
Right, you lie on the visa form to get in.
Exactly. And the briefing highlights the 2024 You Win USA federal prosecution as concrete proof that a lucrative, illicit industry exists specifically to exploit the 14th Amendment.
And they argue that the sovereign state must have the authority to defend its own borders against organized fraud. But there's another argument on the pro side that really stood out in the source material, and it relies on comparative international law. The briefing points out that the United States is actually an outlier on the global stage regarding unconditional birthright citizenship.
This is a highly significant contextual factor. Nearly all of our peer nations have already moved away from unconditional just so.
Right. The UK abandoned it in 1983. Australia ended it in 1986. Ireland, which was the last country in Europe to offer it, removed it via a constitutional referendum in 2005.
India as well.
Right. India abolished it in 2004 to deter illegal migration from Bangladesh. So the administration's defenders argue that reforming birthright citizenship isn't some extremist anomaly. It is actually aligning the United States with the established global trend of modern democracies requiring at least one parent to have legal residency.
It provides a very strong comparative defense. And finally, on the pro side, we return to the Kavanaugh concurrence. His reliance on statutory interpretation rather than constitutional prohibition provides the administration with a credible argument that Congress, and by extension, the executive branch, when interpreting ambiguous statutes, still retains significant authority to define the parameters of citizenship.
Okay, so those are the pillars supporting the new orders. Now let's pivot and examine the strongest legal case against the administration, the counter-arguments that the challengers will immediately file in federal court.
Well, the counter-arguments are deeply entrenched in Supreme Court precedent. The most immediate hurdle is the timeline itself.
That is 6 weeks.
Exactly. The Barber decision, which explicitly affirmed that the 14th Amendment covers virtually everyone born on U.S. soil, was handed down just 6 weeks prior. The challengers will argue that the administration's attempt to redefine jurisdiction in Order 1 is completely inapposite.
Because of the immutability theory we talked about?
Right. As we explored earlier, a foreign lobbyist or an FTO member living in a U.S. suburb is comprehensively subject to the jurisdiction of American law enforcement and courts.
And the challengers will also attack the sheer vagueness of Order 1. I mean, the ELG briefing calls the phrase lobby and act on behalf of foreign governments absolute, quote, void for vagueness bait.
Oh, it definitely is.
Like, how can a fundamental right like citizenship at birth depend on a low-level executive official's subjective, retroactive characterization of a parent's employment?
It's impossible to enforce evenly.
Right. Does a clerk filing paperwork at a foreign embassy count? Does an American citizen who's registered under the Foreign Agents Registration Act, FERA, trigger this clause for their child? It introduces an impossible level of ambiguity into what should be an automatic day one process.
But the most formidable doctrinal barrier the administration faces isn't just vagueness. It is a landmark 1967 Supreme Court decision called Afrayim v. Rusk.
Right, this is where the legal mechanics get really fascinating. Afrayim established a strict constitutional boundary. The government cannot forcibly strip a citizen of their citizenship unless there was fraud in how that citizenship was originally acquired.
Which is why the administration is leaning so hard on the fraud angle in Order 2.
But this is where the logic seems to completely collapse to me. If fraud is required, how can a newborn infant possess the mens reale, the mental intent to commit visa fraud? You are literally imputing the parent's misrepresentation onto a baby the moment it takes its first breath.
You've isolated the fatal legal flaw in the fraud theory. The briefing emphasizes that you cannot constitutionally impute a parent's unlawful conduct to a newborn child.
Right, the baby didn't lie on the visa application.
Exactly. The child acquires citizenship merely by the geographic fact of birth on sovereign soil, not by submitting a fraudulent application. The infant did not deceive a consular officer. Therefore, applying the Afrayim standard to strip citizenship from the child based on the parent's actions is just a massive legal overreach.
And beyond the constitutional theory, the practical enforcement mechanics of Order 2 sound like a complete logistical nightmare.
Oh, absolutely.
The briefing flags severe civil liberties issues here. Like, how exactly will border agents or consular officers screen women to determine their pregnancy intent?
Which is incredibly invasive.
It inevitably raises massive Fourth and Fifth Amendment concerns regarding privacy and unreasonable searches, as well as profound equal protection issues regarding how female travelers are scrutinized compared to men.
The enforcement reality is fraught with peril, and we must also consider the international implications. If the U.S. government successfully denies citizenship to a child born on American soil, and that child does not automatically inherit their parents' nationality under the laws of their home country.
Oh, wait. You run the risk of creating stateless children.
Exactly, stateless children. These are human beings born into a legal void recognized by no nation on earth. And the United States is not a signatory to the 1961 Convention on the Reduction of Statelessness.
So there's no safety net.
No safety net at all. It introduces a massive, unpredictable humanitarian variable into this whole equation.
Wow. So we have covered the legal theories, the data, and the historical precedents. But how is the actual public reacting to all of this? When we step outside the courtroom and look at the electorate, the reaction is not what you might assume.
Not at all. The ELG briefing includes a fascinating section detailing their qualitative coding of public response. They analyzed over 150 visible comments and replies from a Wall Street Journal reader thread discussing the August 6th executive orders.
Right. And the baseline assumption for a comment section dealing with immigration and the president is that it would just devolve into a toxic partisan fight over the policy itself, right? Like pro-immigration versus anti-immigration.
That's what you would expect. But the data revealed a completely different dynamic.
Tell me about the breakdown.
The breakdown of the comments is highly revealing. The single largest block of commenters, representing 32% of the total coded sample, focused entirely on procedure, not on the substance of the policy.
Wow. So they were arguing about the rules of the game, not the score.
Exactly. The dominant framework wasn't a debate about whether birth tourism is inherently good or bad. It was a structural argument about institutional method.
Like how it was being done.
Right. The recurring sentiment was the Supreme Court literally just ruled on this, or if you want to alter the 14th Amendment, you must use Article V to amend the Constitution. You cannot legislate from the Oval Office.
That's fascinating.
It is. This procedural frustration united self-identified liberals, conservatives, and remarkably, even commenters who explicitly supported the goal of ending birth tourism. There was a broad institutional consensus that using executive decrees to circumvent recent Supreme Court rulings is inherently dangerous.
So only 24% of the comments focused primarily on defending or attacking the actual policy merits of fighting visa fraud.
Right.
The briefing also identified some highly specific recurring narratives within the comment section. 19% of the comments fell into a category of mockery or ad hominem attacks, much of which centered around what the commenters dubbed the Melania paradox.
Right. The speed at which the public identifies rhetorical vulnerabilities is always impressive. The commenters immediately retroactively applied the administration's own logic regarding intense scrutiny of immigration history and intent to the first family's own well-documented immigration background.
It just highlights how policies built on retroactive scrutiny often create unavoidable political liabilities for the authors.
It really does. And the public also instantly keyed into the vagueness problem we discussed earlier.
Oh, the vagueness alarm.
Yes. The briefing notes a strong vagueness alarm in the comments. Readers were demanding definitions. What exactly does acting on behalf of a foreign government mean? Does that include AIPAC? Does it include UN employees? Does it include a corporate consultant?
So the public intuitively understood the danger of the void for vagueness doctrine without needing a constitutional law degree.
It demonstrates a very sophisticated baseline understanding of legal boundaries among the engaged public. But the briefing takes this public reaction and connects it directly to a much more cynical, strategic reality: the political calendar.
The midterm clock. The timeline is the master key here. The commenters correctly noted that these explosive executive orders were signed exactly 89 days before the midterm elections.
89 days.
Some cynical readers referred to it as the old faithful distraction strategy. And this leads us to a core concept in the ELG analysis: litigation as a product.
Litigation as a product. This means that the administration's primary goal isn't necessarily to see these policies enacted, defended, and fully operational by November.
They don't even care if it passes.
Exactly. They know that federal district courts will likely issue nationwide injunctions halting Order 1 almost immediately. But the short-term judicial loss doesn't matter because the fight itself is the product being manufactured.
The litigation is a machine designed to generate political salience. It dominates the media ecosystem, it serves as a powerful catalyst for grassroots fundraising, and it mobilizes the political base.
When a judge inevitably strikes down the order, the administration doesn't view it as a failure of policy. They convert that injunction into evidence for a pre-existing political narrative.
They use it to argue that the courts are acting as an elite blockade against the popular will.
Right. The judicial rebuke is metabolized into political fuel. Losing in court is factored into the strategy as a political win.
It's a closed-loop system where they benefit regardless of the legal outcome. That is wild. But this brings us to what I found to be the absolute most fascinating, jaw-dropping paradox in the entire source document. We have to unpack how these new executive orders are violently colliding with a piece of legislation that the president himself signed back in 2025.
Oh, the collision between these executive actions and the legislative record is just magnificent.
It really is. So let's look at the One Big Beautiful Bill Act of 2025, or OBBA. This massive legislative package created a federal program called Trump Accounts. This program is a pro-natalist policy that provides a $1,000 federal seed account, literal cash, to eligible citizen babies born in the United States.
It is essentially a baby bond program designed to incentivize family formation.
But here is the massive, glaring contradiction. The statutory language that created the Trump accounts requires the infant to be a U.S. citizen at birth, explicitly regardless of the parent's immigration status.
Right, regardless of the parent.
Yet these new August 2026 executive orders are designed to aggressively litigate and prevent those exact same infants from being recognized as citizens.
So, wait, isn't the government literally fighting a war against its own signature legislation?
They absolutely are. The briefing views this contradiction through a framework developed by legal scholar Eilert Schurchar, known as the Birthright Lottery. The administration is simultaneously executing two wildly opposing strategies.
How does that even work internally? Well, through the Trump accounts, the state has actively converted birthright citizenship into a highly subsidized, tangible financial asset class. The president himself framed it as a priceless and profound gift. But at the exact same moment, through the new executive orders, the administration is aggressively litigating to restrict the allocation of that very same asset.
They are literally attaching a cash bounty to citizenship with one hand and suing to prevent people from claiming it with the other. The interagency absurdity of this is staggering.
It really is.
I mean, you could theoretically have a scenario where the Department of Homeland Security is actively trying to deem a newborn child a non-citizen under the authority of the executive order, while the Treasury Department has already legally seeded that exact same child's Trump account with $1,000 because they perfectly meet the statutory definition passed by Congress.
It is a bureaucratic nightmare, but more importantly, it creates a massive self-inflicted legal trap for the administration. The ELG briefing identifies this as the major doctrinal sleeper issue of the entire conflict: expressive statutory interpretation.
Walk us through how the challengers will exploit this in court.
When the civil rights groups and challengers file their inevitable lawsuits against the August 6th orders, they are going to introduce the Trump account statute as Exhibit A.
Oh, brilliant.
They will point out to the federal judges that in 2025, Congress debated, passed, and the president signed a law whose entire eligibility formula inherently presupposes the traditional maximalist interpretation of birthright citizenship.
Because the law explicitly grants the money based on the infant being a citizen at birth, regardless of any parental status.
Precisely. The legal concept at play here is an implied repeal problem operating in reverse.
Implied repeal in reverse.
Yes. The challengers will argue that by passing the Trump account legislation, Congress explicitly and recently acquiesced to the broad rule of Justice Solely. They will hand the judiciary a massive separation of powers argument on a silver platter.
They will stand before a judge and say, "Your Honor, the executive branch is attempting to unilaterally rewrite the Constitution via an executive order in direct contradiction of its own signature legislation passed by Congress just last year."
Exactly. It strengthens the 14th Amendment defense with a potent statutory reinforcement.
It is a legal comedy of errors. So we have this incredibly tangled web of contradictory statutes, untested legal theories, and looming midterm elections. How can anyone possibly predict how this will actually resolve?
Well, to attempt to forecast the outcome, the ELG briefing turns to a highly modern analytical tool: financial prediction markets.
Oh, man. This section blew my mind. They refer to it as Hayekian jurisprudence. It is the application of the wisdom of crowds backed by real capital applied to the outcomes of federal litigation.
Right. We are talking about platforms like Polymarket and Kalshi.
Yeah, where traders place actual financial wagers on how the Supreme Court will rule on specific cases. And according to the source material, these markets are seeing millions of dollars in trading volume on major constitutional questions.
The track record of these markets is what forces legal scholars to take them seriously. They actually predicted the outcome of round one with astonishing accuracy.
Wait, really? They called the Trump v. Barber decision.
They did. On the eve of the Trump v. Barb decision, Polymarket hosted a contract on whether the Supreme Court would strike down the original 2025 birthright order. The market had priced the probability of a strike down at 94%. Hours later, the market resolved as a yes. They demonstrated a similar predictive capacity regarding a massive tariff case earlier in 2026.
But I need to introduce some nuance here, based on the University of Chicago Law Review study that was cited in the briefing. The data suggests that we shouldn't view these markets as omniscient legal oracles.
No, definitely not.
Because didn't the data show these markets are basically just reacting to oral arguments, not actually predicting anything based on the legal briefs?
That is the essential caveat to Hayekian jurisprudence. The mechanics of the 2026 tariff case perfectly illustrate this limitation. The prediction market for that case had nearly $5 million in active volume.
$5 million.
Yeah. And from the moment the market opened in September, all the way through the months-long briefing period where top-tier constitutional lawyers filed exhaustive arguments, the odds of a government victory remained completely flat, hovering between 40 and 50%.
So the market extracted absolutely zero predictive signal from the written legal briefs.
Exactly. The traders either weren't reading the briefs or they just couldn't translate the legal jargon into a probable outcome.
But the dynamic completely shifted during oral arguments, right?
It completely shifted on November 5th. As the Solicitor General stood before the justices and faced intense, skeptical questioning, the market reacted violently in real time. The odds of a government victory collapsed intraday, plummeting from 50% down to 18%.
Wow. The market instantly recognized that the government's lawyer was drowning.
Exactly. The market eventually settled around 25% and drifted there for months until February, when the Supreme Court officially struck down the tariffs in a 6-3 decision. The insight here is that these markets exhibit what economists call semi-strong efficiency.
Meaning they are incredible at aggregating public information.
Yes, like the tone and tenor of an oral argument, and they do it faster than any single pundit or news network. But they lack the capacity to anticipate the outcome beforehand, based purely on the underlying legal texts.
They are a highly sensitive barometer of consensus after a public event, but they are relatively modest profits before the event occurs. So, knowing this limitation, how does the briefing use this framework to map out the likely path forward for these new August 6th orders?
Well, the litigation pathways are fairly predictable in the short term. Order 1, the aggressive attempt to deny citizenship, will almost certainly be enjoined by federal district courts nationwide within weeks, if not days.
Right. And then what?
The genuine unknown, the exact type of binary coin flip that prediction markets struggle to price early on, is whether the Supreme Court will grant certiorari. Will the justices agree to take the case up again to specifically police the boundaries of the historical exceptions, or will they simply deny review?
And if they deny review, what is the functional outcome?
If the Supreme Court denies certiorari, it acts as a quiet structural rebuke to the administration. It allows the lower court injunctions to remain in place, and it lets their 6-week-old ruling in Barbara stand unqualified as the definitive law of the land.
What are the odds on that?
The ELG briefing's internal modeling estimates there is roughly a 55% probability that the lower courts strike down the new orders, the Supreme Court denies review, and Barbara remains untouched. However, they estimate a 35% probability that the Supreme Court takes the case in 2027, feeling compelled to clarify the exact limits of the jurisdiction clause.
The briefing also touches on an element of prediction markets that sounds like the plot of a legal thriller. The ethical unknown of reflexivity.
Oh, this is fascinating.
Right. As these markets grow and potentially handle tens of millions of dollars in volume on single court cases, we enter completely uncharted territory.
The reflexivity frontier asks a really dangerous question. Do the market prices eventually begin to influence the litigation behavior itself?
Like, if a market prices the probability of a law being struck down at 94%, does that publicly visible metric influence a party's willingness to negotiate a settlement?
Exactly. Or does it subconsciously impact the Supreme Court justices who are aware of the market's consensus? Furthermore, the source notes that lawyers, paralegals, and court clerks possess highly sensitive non-public information about pending cases, and there is currently absolutely nothing resembling the SEC's insider trading architecture governing these legal event markets.
It is the Wild West of legal finance. Well, we have covered an immense amount of ground today. Let's pull back and summarize the journey we've just taken. We started with a sweeping Day 1 executive order in 2025, watched it meet a definitive Supreme Court smackdown, and then observed the administration's pivot to the asymmetric warfare of iterative narrowing with these two new August 2026 orders.
Right, the hacker strategy.
Yeah. We explored the massive compounding effects of the counterfactual data, and we dissected the profound, self-inflicted paradox of the government simultaneously subsidizing citizenship through Trump accounts while aggressively litigating to prevent children from claiming it.
We also examine how the public, as seen in those WSJ comments, intuitively rejected the procedural dangers of rule by decree, while prediction markets struggle to accurately price the legal maneuvers without the public theater of oral arguments.
So why does all of this matter to you? It matters because this scenario is a masterclass in how the boundaries of the Constitution are tested, stressed, and potentially broken in real time. It reveals how political narratives are engineered through the machinery of the courts, where the litigation itself, the endless fight, is the actual product being sold to the electorate, regardless of the final judicial outcome. Understanding this process is about understanding how the levers of modern power are actually pulled.
And if there is one final provocative thought I want to leave you with, it builds directly on the briefing's conclusion regarding the concept of zero-sum finality. We are all taught a very clean version of civics. The Supreme Court has the final word on the law. The ruling comes down, the debate ends, and the system moves forward.
That's what we learned in school, yeah.
But we are now entering an era where an executive can simply change a few words in a document, stretch the interpretation of a 19th century historical exception, and reissue a decree over and over again. In that environment, is a Supreme Court ruling ever truly final? At what point does a system of continuous iterative relitigation stop being a legal strategy and start fundamentally breaking the boundaries of the Constitution itself?
That is a chilling thought, and it's the exact question we are all going to be watching unfold over the coming months. Thank you for joining us on this deep dive into the August 6th executive orders and the future of birthright citizenship. Led by Jack Russo, Computer Law Group LLP is a bespoke business litigation and founder-friendly boutique law firm with offices and licensed attorneys in Silicon Valley, New York, and Tampa Bay. And you can reach Jack at jack@computerlaw.com and his team at www.computerlaw.com, where the newsletter we refer to is published in detail and readily available, commitment-free, with no paywalls or other charges.
Tune in next time on The Valley Current.